forest rights. A new law was made in the year 2006 called the Forest Rights Act by Government of India. What is its objective? Its objective was very clear that ever since the Indian forest law came into existence, the entire operation with regard to the forests, its management, its use is entirely at the whim and fancy of the state and state agencies. They have a complete monopoly over the forest. People did not matter in the whole scheme of things. It's understandable that the British could have that kind of an attitude because power vested with the crown in England. But for the people, they were only the subjects of the law. They were only the objects of law. They were not the masters of their destiny. Even though many of them were living within the forest area or were dependent on the forest, living in its periphery. They had no rights at all. They had only concessions at the base of the state. This is considered to be a historical injustice caused by the British Raj and perpetuated even in independent India, even after 50 odd years of our independence. The government of India took upon itself the responsibility of righting this historical injustice. It wanted to address the long-standing insecurity of tenure and access right and to provide that kind of a protection of communities of people who are just displaced, who are living there within the forest area without any kind of a relief for them by the state departments for their developmental purposes, to recognize and vest in these groups of people certain rights, including right of occupation. And for that purpose, a new law was made. A law for protection of the rights of the forest dwellers, scheduled tribes and scheduled people who are living within the forest area and other people who are living within the forest area whose rights were jeopardized because of the working of the forest law. The Forest Rights Act of 2006. The law said that this is a right that is available for forest dwelling scheduled tribes people and all other traditional forest dwellers. They may not be tribal people, but they have been living in the forest area. For how long? For at least 3 generations. Under this law, one generation is supposed to be 25 years, and so if you are able to establish by the year 2006, because that's when the law came into existence, that for the last 75 years that your family have been living there, then you will get a right of certain kinds of rights which you have been enjoying in this forest area. And so this is a law which provides for a framework for recording forest rights to recognize them as integral to the very survival and sustainability of forest ecosystem. So the symbiotic relationship between the people and the forest is sought to be re-established through this particular law. Let's have a quick look at the rights. The following rights are the ones that are recognized. That if you have these rights, please remember these are rights which are recognized. This law does not create any new right. You have been traditionally, customarily enjoying these rights that has been actually marginalized for a lot of time. Now you are going to reassert that. What is that right? If you are residing there, including tenural habitat and habitation of primitive tribal groups, pre-agricultural communities living there, you will have right of residence. You were also not only residing there, were you engaged in cultivation? Well, that cultivation right of an individual or a group of people for your livelihood, right like Nista, that is something that is practiced in Maharashtra, a traditional right. In fact, Maharashtra is one of those exceptional cases where under that law there, this Nistar right is recognized even under the Forest Act in that particular state, and the same gets amplified here. The third one is the ownership right over minor forest produce. It is not no longer a concession. If you have been getting this forest produce all the while, like fishing, grazing of forest land, collection and use of certain forest minor property, well, you can continue to have that. You have ownership right. So you have these rights and entitlements, but these rights and entitlements that you have are subject to one restriction. And that restriction is that these rights should not come in the way of protection, should not come in the way of regeneration, should not come in the way of conservation, should not come in the way of a proper scientific management of forest resources. Supposing in exercising these rights, these aspects were an integral aspect of your existence there, continue. But supposing it came in the way of that, even if you had this traditional right, you can no longer exercise because it is against forest conservation. So the idea is forests have to be conserved. And in conserving the forest, if communities of people who are dependent on the forest had certain kinds of claims over that, it can be there as long as it won't come in the way of these particular kinds of non-negotiable conservation ethics. And so, if there was traditional right of hunting, trapping of animals or anything like that, completely excluded because it would actually harm, injure, and even kill animals. And that is an offense under this law. Right of conversion into titles. See, you had right of residence, right of settlement, and we would like to give you the same kind of a right as you would have in revenue villages. In revenue villages, people had settlement rights, and you will have the same settlement right here also. Access to biological diversity and community right to intellectual property and traditional knowledge related to bio and cultural diversity, we vest in you, that is recognized for you. You have the right to be rehabilitated if you have to be moved out of this area for any reason, either for forest development or for any other developmental activity. You have a right to be rehabilitated within the forest area to continue to exercise this right. Or if it is inevitable that you have to be relocated from here and put elsewhere, then you have a right to an alternative land when you are being illegally evicted. You have a right to basic civic amenities. In addition to the rights that you enjoyed traditionally, you have modern rights of civic amenities and that the central government to provide for limited diversion of the forest land upon the recommendation of the Gram Sabha to make provision for schools, hospitals, roads, and tanks, etc. Even the forest dwelling people have these kinds of entitlements, as the civilized people would have as citizens of India, and they should not be denied any such kind of a claim. So, civic amenities also should be provided to them in this area. The nature, extent, and limits of this right is that you, as a forest dweller, you, as a forest dependent community, you have this right as long as you live there. The moment you want to move to the forest area, the right gets extinguished. If your progeny are there in that forest area, it's a heritable right, but this is not something that you can transfer to anyone. You have to enjoy it, your children have to enjoy it, your progeny have to enjoy it, the succeeding generations to enjoy, while still being within the forest area. The moment you take a decision of having a permanent residence elsewhere, then your right gets extinguished. And supposing you have to be moved out, you have to be displaced, only after rehabilitation it can be done. Now, supposing you had vast expanse of forest land for your family, for your community, for occupation or for cultivation. Now, the law is clear. Since the practices have been different in different regions of India, we have a cap, a maximum of 4 hectares of actual area of occupation or cultivation is allowed. Even if you had more, we will not allow you. Only this much is available for your family. Each right is coupled with a duty to protect wildlife, taking care of the catchment areas of water resources, taking care of cultural and natural heritage. There is also a provision made under this law of creating what are called as critical wildlife habitats within the forest area. There may be certain areas which are having certain kinds of wildlife which are endemic. That means they are found only there. For their survival, sustenance, and flourishing, they should be left without any disturbance. But supposing there is a tribal settlement or some forest dwelling community having certain rights as has been described under this law are also there, then if it is established, once again upon the recommendation of the wildlife department, that it is inevitable that these people will have to be moved out of that because leaving them alone is critical to the very survival of the wildlife. That's why it's called as critical wildlife habitat. Then they can be displaced. But the law is very clear. There is a provision here which says that if they have to be displaced, they can only be displaced upon completion of the process of resettlement. So you have to give them an alternative land, you have to resettle them, then only you can take over. That this is an exclusive area meant only for protection of wildlife, no humans can exercise any right over that. What is the process whereby the rights are going to be determined, rights are going to be recorded, and these rights are going to be put into application? For that, it is a simple procedure. Within every panchayat, there is a general body called as the Gram Sabha. And it is this Gram Sabha which would initiate this process. It would identify those very people in that particular area who had some right or the other traditionally over them. And this Gram Sabha would pass a resolution. And in this resolution, they will identify the people, they will identify the community, they will identify those rights that they should have, and will come up with a resolution. And through that resolution, it will go to what is called as the subdivisional level committee, SDLC, which will peruse this particular recommendation of the Gram Sabha and then match it with the revenue records that are available, look for evidences and whatever that has been supplied to it, on the basis of which it will take a call of either recognizing whatever that has been claimed through that resolution or recognition subject to certain limitations and restrictions, or not recognizing them when there is no sufficient evidence to support it. And this decision of the subdivisional level committee is final and binding. And it's only through that it will be put into records. And once it is put in the revenue records, a record of right is being created thereby. This particular decision and determination by the subdivision level committee can only be challenged before the district level committee as an appeal, and the district level committee would decide on that, and the record of rights as decided in appeal by the district level committee is final and binding, and that will go to the record of rights. To oversee the implementation of this, there is a state level monitoring committee which oversees the process of recognition and vesting of rights. Initially, the power of overseeing the working of this law was vested with the Tribal Affairs Ministry and to be transferred to the Forest Department once, as a transitional measure, all these are put into position, and then the forest and the wildlife authorities would administer the implementation of this law. What is this law in terms of its effect? By and large, all the rights recognized here are binding and they override all other laws which come in conflict with this law, subject to one condition, that other than declaration of rights and entitlements, the working of this law is in addition to and not in opposition to any of the laws that are in operation in India. What is the reality check about the working of this law? This law was made in the year 2006, and if you take the developments in the last 14 years, there is large degree of success in the implementation of the law in some of the states like Chhattisgarh and a few others, especially when it comes to the settlement of the rights of, after recognition of the scheduled tribe people. The tribal people's rights are protected all over India by and large under this law. But the non-tribals who are forest dwellers, as to the determination and settlement of their claims, things are not that final. That's mainly because of competing claims between different departments of the government. The Tribal Welfare Ministry is only interested in the tribal welfare and it is not bothered about the non-tribal people living in the forest area, and so there is no one to take care of their interest. And there are a number of authorities. The Tribal Welfare Ministry is there to put forth the claims of the tribal people. There is no one to put forth the claims of non-tribal people, and so they're made to fend for themselves. In determining these rights, it is the revenue authorities who should be engaged. In transferring these rights in their favor and vesting them with them, it is the forest and the wildlife departments that are to be involved. So there are problems of characterization of rights, there are local politics in the panchayat. All these have actually not given complete effect to the working of this law. There are problems of inclusion and exclusions, and Gram Sabha being a very, very minor entity in the whole scheme of governance, it is a very simple, minimalistic role in the entire process, although that is supposed to be the one which would initiate the entire process. And there's also the problem that there is an exaggerated claim being made by the wildlife department of creating critical wildlife habitats, especially where there are rights of these communities are recognized so as to evict them, and the claims of these people are still being prosecuted in courts of law, and so the law is in still a fluid state of implementation. Good ideas, great purpose with which the government wanted to reclaim the lost right of the communities of people, it is still a law being worked, not to its fullest, but over a period of time, it is being still done. There is this Compensatory Afforestation Fund Act. The idea was that through various means and mechanisms, a lot of fund got collected, and the means and mechanism whereby these funds that were so collected, that has been mentioned as to how these funds were collected. Utilization of it for afforestation was not something that was always happening because there were no guidelines, there were no clear instructions under the forest law. And so the need for a new law for number one, whatever that's so accumulated, the huge sum of money running to around 40,000 crores of flowing it back for afforestation purposes, a new law was created called the Compensatory Afforestation Fund Act. This law was made for regeneration of forest to compensate for the forest land lost and converted into non-forestry purpose. So to have forest to be created in those areas and things like that. And there are several cases which actually made the government to think of coming up with a set of guidelines, and that has been provided under this law. These two slides very briefly describe what this law is about, that for what purpose it should be used, how it should be used, what should be the method and manner of determination of the value of the forest land. There is some arithmetical calculation that is being done of determining the net present value of the forest land so as to get the compensation for that to be put in the fund, and how it has to be put to use have been put together in this. It's too early to draw a final conclusion as to how this law is working, but there are a few instances where the fund has been put into clear application, and since it has been made only just 4 years back, results and the level of accomplishment of the objectives of this law are yet to be ascertained with great degree of clarity. And so it's too early to judge this law, but it's good that at least a mechanism has been evolved, at least now, of something that was not done for well over 80 years of the working of the forest law in India. To give to the forest for the purpose of conservation something that people would owe for having put the forest to so much of destruction, to compensate for that forest loss, to use that money so collected for the purpose of regeneration of the forest area. That is the objective. This comes to a closure of our discussion on the entire law concerning forest conservation, forest management, and forest rights. In the next segment, the last part of our discussion in forest and wildlife law is going to be the inquiry on the wildlife protection and its management. And that will be done in the next session of our discussion in this particular area of law.